welcome to Mind Over Matter. Today it's really a pleasure to welcome attorney Robert Weber, who is the former executive director of the Mental Health Legal Advisors Committee and who's widely known for his advocacy on behalf of the chronic mentally ill. And I've had the pleasure of working with you, Robert, at Bridgewater State Hospital when we were often not on the same side of the table as today, but on opposite sides of the table around our attempts to get commitments or get permission from the court to treat someone involuntarily. And you were always a force to be reckoned with. So perhaps we could pick up with some of that and talk a little bit about the right to refuse treatment. Whose right is it? And how do you and I sort of resolve our differences when I have a patient who seems to need antipsychotic medication because of a psychosis, and yet the patient refuses? And you come in as an advocate for that patient and may see the situation differently.
Well, I think it's important to understand that the phrase right to refuse treatment is a poorly constructed and inaccurate description of what the right is. Because the right that we're talking about and the right that was recognized by the Supreme Judicial Court in the cases that predate the Rogers case is simply the right that all of us have in Massachusetts not to be treated without our first giving informed consent. And all the Rogers case really did was give hospitalized mentally ill people the same right that everybody else in this Commonwealth has not to be treated without our informed consent. And what it did was it said to psychiatrists working in psychiatric hospitals that they had to treat their patients the same way that all other doctors in virtually any other medical environment treated their patients, which is that you as a physician diagnose a person's condition, prescribe a treatment, be it antipsychotic medication or surgery, and before you implement the treatment in the absence of an emergency, you seek informed consent from your patient. In the same way that you wouldn't, do an appendix operation on somebody without getting informed consent, a hospitalized, even a civilly committed, forcibly hospitalized mental patient whose psychiatrists think he needs treatment with antipsychotic medication still has the right to give informed consent before he's treated. And that's all the Rogers case says. It's nothing different from that. It adds an additional caveat or additional procedure which says that the treatment with antipsychotic medication, because of the nature of those medications, is so invasive that a guardian on behalf of an incompetent person can't provide the treatment decision. A judge has to do it. And the judge has to try to decide what the patient would want if he were competent. But that's really no different than the same rights that we all have anyhow.
Of course, the devil's in the details. I mean, the situations are usually ambiguous because I might think that somebody is unable to give informed consent, and you might argue that no, they are able to give informed consent. So I appreciate the clarification, but you just sort of move the problem to a slightly different level, but it's the same problem. How are those judgments best made?
Well, I don't think that the problem is sort of any more difficult with respect to mentally ill people. The judgment is made by a judge. I mean, actually not the Rogers case, the Sakowitz case made it pretty clear that only judges can decide whether or not somebody's incompetent to make treatment decisions. And if they are incompetent, then the judge makes a decision about what the person would want if he were competent. So take a psychotic person who is confined to a psychiatric hospital, whose psychiatrist thinks he requires treatment with an antipsychotic medication. The first thing the psychiatrist is supposed to do is consult with the patient and see if he can get informed consent. If the patient is incapable of giving informed consent, then the psychiatrist can file a petition in a court alleging that the patient's incompetent to give that consent. And if the court agrees, they find him incompetent, and then they go on and make a medical decision. My experience is that a great many mentally ill people may be competent to give informed consent, but the psychiatrists aren't willing to work with them. In other words, the patient's refusal is an issue that ought to be dealt with in treatment. Instead of the psychiatrist in the hospital simply saying, well, he's mentally ill, so he's crazy, and if he doesn't want to do it, therefore he's incompetent, we'll run to court. The better psychiatrist will work with the patient, treat their refusal as a treatment issue, talk to them about why they're refusing. Many patients aren't aware of the symptoms that they're exhibiting that people use to characterize their mental illness. And frequently a psychiatrist working with the other members of the treatment team can help the patient understand what their symptoms are and then explain to them that the medication can be used to treat the symptom, and thereby form an alliance with the patient and achieve informed consent. It seems to me that that's the better approach for two reasons. The first is it treats the patient with a sort of the dignity that they deserve and are entitled to. And secondly, in a long-term basis, a patient's not going to be confined to a hospital forever. And even if you obtain a guardianship, which I think we're going to talk about a little later, a guardianship that extends beyond the hospital stay, it's very difficult when somebody's outside of a hospital in an uncontrolled kind of an environment to chase them around and force them to take their medication. So if the doctor can and the treatment team can help them understand why they need the medication, I think they're better off in the long run.
Have you actually, as their counsel, talked some of your clients into taking medication so the petitions could be withdrawn?
Well, as an attorney for a client, I don't ever talk them into anything. I don't feel that that's my role. On the other hand, I explain to them what their chances are in winning or losing a certain case, and I try to get them to understand that the doctor's not necessarily the enemy, and that it might make sense talking to the doctor about what his symptoms are, and although the patient may not acknowledge that he has the symptoms, you can sometimes show them in the chart or show them in their life experience that brought them into the hospital that other people saw that they did have these kinds of symptoms, like the police who brought them in or so forth. And I can certainly suggest to them that one of the things that happens if they try the medication and see if it doesn't work without going to court is that they retain the right to try it, and if it doesn't work, to stop trying it. They haven't lost anything by it. On the other hand, and they keep control of it. So I've certainly, my experience is it's more difficult to get some doctors and hospitals to negotiate with the patients than it is to get patients to agree to do it. It's much more difficult to get. If I go to a doctor and say, well, my client's willing to try the medication, frequently what happens is I'll say, my client's willing to try the medication. The doctor says, well, he's an incompetent acceptor, and therefore we can't do it that way. And I say, well, why is he an incompetent acceptor? And they say, well, because he doesn't truly understand the symptoms of his schizophrenia. He only wants to take the medication because he needs to get out of he wants to get out of the hospital. And my answer is, that's a sign of competency. He may not truly understand all of the symptoms of his schizophrenia, but if I have bypass surgery, I may not understand all the problems with my heart. But it seems to me that it's a competent understanding of the situation to know that I'm locked up in a mental hospital, that they're not going to let me out unless I take this medication. And if I take this medication, it'll make me better enough, at least in the eyes of these other people, that'll let me out of the hospital. In my view, the key issue for competency is not whether the patient understands whether or not he's schizophrenic or paranoid or something. The key issue is whether or not the patient can really appreciate the doctor's descriptions of the side effects. Because one of the reasons you get informed consent is so that you can tell the patient what the risks are of the treatment, so the patient will understand them.
And the risks of non-treatment.
Yeah, but the reason you're getting the informed consent when you give him the treatment is so that if he has a side effect from the treatment, he's accepted that risk and you don't have liability problems. So it seems to me that if you do have a patient who is a so-called incompetent acceptor, but is so psychotic that if you talk to him about tardive dyskinesia or some of the other side effects, and he's totally incapable of understanding that, then it seems to me you do have an incompetent acceptor.
Let's flip it around. Have you won some cases that in your secret heart of hearts you thought you lost? In other words, the patient's right to refuse, pardon the expression, is upheld by the court, or the Commonwealth didn't make its case for incompetency, and yet you felt that somebody was not getting treatment that they might benefit from?
Well, those are two very separate questions.
Okay.
Because I can't think of a case that I won on the competency side where the court found somebody competent and I thought they probably were not competent. And it's no secret that although the burden of proof is on the petitioner, on the hospital, or the person seeking guardianship, the vast majority of patients don't win these cases. The courts are...
Oh, 99%.
Yeah, the courts are very, very sympathetic to the petitioners.
Right.
But the second part of your question was, have I won cases where the patient was found competent and then didn't take treatment that was in his best interest? I don't know the answer to that because I don't try to make judgments about what's in the best interest of my client. Because the law, I mean, one of the things that the Supreme Judicial Court said in the Roe case, which is the case that predated Rogers, and Richard Roe was outpatient. He was living in the community, and his family, and he had been in a hospital, and his family wanted to give him Prolixin, the hospital wanted to give him Prolixin, and he didn't want it, and he refused it. Is the court said he had the right not to live in the community, be mentally ill, but not incompetent, and he wasn't incompetent, and not take the medication. Now, a lot of people would think that it wasn't in his best interest because he wasn't reaching his full potential, and if he was treated with the antipsychotic medication, he would have lived, by most standards, a more successful lifestyle. Okay. But the point is that the Rogers case and all the cases make it clear that as long as he's not incompetent, and as long as he's not putting himself in a risk of harm or others in a risk of harm, he has the right to decide that he doesn't want to take this medication and maybe achieve a potential that his doctor and family thinks he can.
All right, well, why don't we pick up with this case and maybe talk about involuntary hospitalization.
Okay.
Thank you. Take a break.
Oh my God. The fear of not breathing or not being able to breathe is worse than anything in the whole world.
This is a healthy human lung.
My chest gets tight, my heart starts to beat really fast.
This is a lung removed from a patient who had emphysema.
I can't think, I try to calm myself down.
This is full of carbon from smoking.
And I start to hyperventilate and I'm getting no air. There's nothing that's scarier.
Disaster strikes, and you want to help. But what happens when the tragedy is being played out on a smaller stage out of sight of reporters and television cameras? How do you know you are needed? Hello, I'm Angela Lansbury for ChildReach. In many of the world's poorest countries, poverty devastates lives with no less intensity than a hurricane or a civil war, especially the lives of children. ChildReach, one of the world's largest and most experienced sponsorship organizations, creates a continuing connection between a sponsor and a needy child overseas. This leads not only to a caring relationship, but also to family and community-based self-help programs designed to bring clean water, education, health clinics, and most of all, hope to the sponsored child and his or her family. To find out more about Child Reach, please call 800-603-1600. I'd be so grateful.
Mom. Come on, Courtney. Come on, baby. Come on. Come to Mama. There you go. You can do it. You can do it.
At Easter Seals, the first step was helping Mom. Because sometimes mothers of disabled children need encouragement too. Support Easter Seals. Give the power to overcome.
Good girl, Courtney. Good girl.
Robert, I'd like to just go back a little bit to someone leaving the hospital going into the community, because I know it's of concern to many family members that Johnny, for example, 28 years old, living at home, clearly does very well when he takes his medication, but then gets embarrassed, reluctant, ashamed, stops taking his medication, regresses, becomes more difficult to manage at home. What are these family members to do? And the rights question, who has the right to do what in a situation like that?
To me, this is the most difficult issue that I deal with on a regular basis, because although you know me more from representing patients in commitment hearings and Rogers hearings, I also have a fairly substantial practice representing family members, and I do a lot of guardianship work from a petitioner's perspective. And frequently the most difficult interview I have is with a client who's a couple in their mid-60s who comes to me and says that their son or daughter is going to be discharged from a psychiatric hospital for the 4th time and is on medication and doing pretty well. And they've called me because their son's psychiatrist said that he's still incompetent. You need to get a guardianship so you can continue to force him to take medicine outside the hospital.
So the hospitals are, is it fair to say today, less willing to initiate the process?
No, sometimes the hospital is willing to initiate the process, but in either case, sometimes they'll just encourage them to contact an attorney, and a lot of the hospitals know me, so they'll contact me. And the most difficult thing to explain to people is that, yes, if the hospital is willing, or the doctor is willing to sign a medical certificate stating that the patient's incompetent, we can probably obtain the guardianship, and even a Rogers guardianship, so that we can convince a probate judge to declare that their son is incompetent and that they should be named as their son's guardian with the authority to consent to the use of the antipsychotic medication, the same medication he's getting in the hospital and the same medication frequently that he stopped taking prior to this admission to the hospital. But the difficult issue is, and the difficult thing I have to explain to people is, that there's no guardianship police. And that is that even if they obtain the guardianship and they say to their son, who may be, anywhere from 25 to 35 years old, I'm your guardian, I'm telling you, you have to take the medication. And their son says, I'm not taking it, and I'm leaving, and I'm going back into Boston to go live with my friends, or I'm going to hitchhike across country. The law doesn't have any real good answers for that, because unless the patient regresses to the point that there's a likelihood of serious harm, unless they're hospitalized, you can't lock them up back in a hospital. Although you're their guardian and the probate court has given you the decision-making power, which means and that you then have the authority to talk to the psychiatrist and hear from the psychiatrist about whether or not the patient is taking the medicine, and you have a lot more standing in the treatment team, which I think has some benefits. You don't really have a club that you can hold over the patient's head and say, take the medicine. And it's not uncommon for me to sort of lose the business from my perspective of obtaining the guardianship and telling people that obtaining the guardianship will not or may not accomplish what you need.
Can't hurt, though.
Well, it can hurt, and there are some suggestions that I've used with families, and sometimes it's successful and sometimes it's not. And it varies tremendously, and I don't have any idea how to advise people how to select this, because generally speaking, I don't have any knowledge of the patient. But the psychiatrist certainly does, and frequently the family does. And there's two things that you can accomplish in some cases. The first is patients don't want to be under guardianship. And if they leave the hospital, they're usually in reasonably good shape, at least better than they were when they were hospitalized. And if the doctors agree that they're ready for discharge and they've been taking the medication, they're frequently sort of competent enough to keep taking the medication. And I've certainly advised families that one of the things they may want to tell their son or daughter is that they don't want to seek a guardianship, and they really want their son or daughter to succeed, but they will seek a guardianship if necessary. And it's sort of...
Is it ever dangerous? I mean, does it ever, result in the relationship between parents?
Well, I was going to get to that, because that's a separate issue.
Okay.
But I think that sometimes the family can say to their son or daughter who's being discharged, as long as you stay on your medication and are doing well, and we're going to help you do well, we're not going to have to resort to a guardianship, but we might. And a guardianship means that you're going to lose a lot of your basic civil rights that we don't want to do. And frequently, patients will respond to that in a way that makes them continue to take their medication and do pretty well. That's some cases. Other cases, there are cases where you can obtain a guardianship and the patient, although he doesn't want to take the medicine, and given his own rights wouldn't, will say, all right, the judge says I have to do it, I'll do it. They're sort of resisting but not resisting, and you know yourself that there are patients like that. I don't know how to advise people how their son or daughter reacts. They don't know their son or daughter. The other question you asked, is it dangerous or advisable for the parent to be the guardian? That raises another whole set of issues. There have been actually articles written about this. I think it's better, in my experience, for the parent not to be the guardian. If there is somebody else, either a brother or an aunt or an uncle, or enough financial resources to hire somebody to act as the guardian, frequently the parent can then stay being the parent. Because when you place an adult under guardianship, you treat them like an infant. You bring up all of the parent-child issues that had when they were young children and adolescents. And with all those kinds of struggles, and you reinvent them all again. And frequently, if you can find somebody to act as a guardian who is detached, who is objective, the parent can remain an ally with their child. Matter of fact, my partner, Elizabeth Baum, does a lot of her practice is acting as the guardian. For mentally ill people at the request of family members. And she may work with the family member. I mean, she has a case right now with a pretty psychotic young woman whose sister is, there's no parents around. Her older sister, who's a very successful professional, is managing the financial affairs, but the sister did not want to be the guardian, and Liz is the guardian, and Liz is the one who decided, after this woman was most recently pink-papered, that she was going to give up her apartment and not let her go back and live alone, and was going to tell her that she had to go live in a supervised housing or some setting where there are other people around. And although the patient's struggling with it, she's not struggling with her sister. She's struggling with this lawyer who is objective and independent, and she can remain and keep some kind of an alliance with her sister, which I think is good.
We only have a few more minutes before another break. About involuntary hospitalization. So when does the situation begin to get, let us say, out of hand sufficiently where that becomes a consideration for the family? And let's assume for the moment, for discussion, there's no guardianship in place.
Well, I mean, the legal standard is that the failure to hospitalize will result in a likelihood of serious harm by reason of mental illness. And that means that A, the person has to be seriously mentally ill, and B, they either have to present a situation where they're harmful to themselves because they're suicidal or self-abusive, or harmful to others because they're attacking people. Or there is a third category where they are so confused because of their mental illness that there's a very substantial risk of physical harm because they can't care for themselves.
And that has to be now. I can't argue that it will be next week based on my experience with my own child.
No. If you want to commit them, it has to be now. It has to be at the time you do the hospital, at the time of the court hearing. That's the only time it can be. And you have to prove it beyond a reasonable doubt.
But the imminency has to be, the danger is now, not I know the situation well enough to know, because it's happened 5 times in the past, that in 1 week from now, he is going to be so flagrantly psychotic and he will be a danger to himself. And, Your Honor, I would like to avert that by having him admitted today.
If he doesn't want to go in the hospital and he's not committable, or, well, understand in Massachusetts you can be locked up for 24 days without ever seeing a judge. So to get somebody into a hospital, all you as a family member have to do is convince a psychiatrist that the person's committable. The psychiatrist can write a pink paper, which can have the person held in the hospital against their will for 10 days. And then if they need to stay longer than that, the hospital can file a commitment petition, and the person can't go to, and the hearing has to be held within another 14 days.
Oh, so that's how
So the person could be locked up for 24 days without ever seeing a judge, but the doctor, the psychiatrist who writes the pink paper, is supposed to be saying that the person is, as the doctor examines him, at the time the doctor examines him, that the person is dangerous. And if I don't put him in the hospital today, I'm going to prevent. There's a risk of harm today. But on the other hand, it's possible that you could get a guardianship and get some forced medication in the community.
How quickly would it take?
In an emergency, or
in an emergency?
If the person was like floridly psychotic and refusing to be examined, you could get it in a day or two. I mean, you can get it fairly quickly. The hardest thing is getting a doctor to write a medical certificate, but assuming that the doctor has seen him within the last 30 days, you could get an ex parte, that's without notice to the patient, emergency guardianship fairly quickly. Although for Rogers, you'd probably have to get counsel for the ward. It'd probably take a day or two, but it could be done fairly quickly.
Can be done fairly quickly.
And of course, the Rogers case allows them to treat in an emergency at least once to prevent a further deterioration.
Before the break, are we not hospitalizing enough people today because of civil rights issues? It has to be a quick response.
I have no idea. I can't tell you that. Although, I think that's the wrong question to ask. After the break, I'll tell you what the right question is.
Okay. Keep me guessing. Thank you.
Best friend thing. I've known Danny since preschool. Me and Danny, we like to wrestle and stuff. Fifth graders, they're so dumb. They're goofy. He's a good basketball player, a good dribbler, good thrower. I love man. Give me a break.
At Easter Seals, we know the most important part of being a kid with a disability is being a kid. With your support, we offer help and hope.
Imagine yourself serving in today's Peace Corps. I wanted adventure. I wanted to go out, learn about a new culture, learn a new language, and bring it back to the United States.
You know for sure for 2 years it's going to be like nothing you've ever experienced. I joined the Peace Corps because I think Peace Corps as a development organization is one of the best in the world.
My dream of becoming a physician, if anything, has become enhanced.
The best part of my experience here, I think, as a volunteer is that I found a second family.
I think one of the best things you can do with your time, it's a great program where you can come and help people out. I'm excited about it. There's a role for you in Peace Corps. It never really feels like work. You love what you're going through. You're helping people, you're working in the community, and people really appreciate you so much for every little bitty thing that you do.
It's fun.
Make a difference. Join the Peace Corps. It's the toughest job you'll ever love.
Hank, you ever think about putting something away for the future?
What are you talking about?
United States savings bonds, Hank.
What do you know about United States savings bonds?
Actually, they're one of the safest investments you can make. You get competitive interest rates and up to a 30-year interest deferral from federal income taxes. So, what do you think?
Well, I have to admit you were surprisingly persuasive. United States savings bonds. Sign up through your company's payroll savings plan.
Suggest that that's the wrong question.
Well, I don't know the answer to that question. My sense is that the courts are conducting the same number of commitment hearings as over the last 4 or 5 years. Prior to that, I think there were more. But there were less. Commitment hearings have to be initiated by the hospital. And there are less hospitals around. And there's certainly less, with the closing of the state hospitals, long-term kinds of hospitals around. But my sense is, from people I talk to, mostly doctors and other people, is that patients are committed more, but they don't stay in the hospital very long. And that they're committed and then discharged before they're fully treated. And then, because they're not fully treated or successfully treated, they're recommitted, they deteriorate, and they're recommitted. And my sense is that's more a factor of managed care than it is of the law. Because when they're committed, you're committed for up to 6 months, at least the initial commitment, which means that the hospital has the right to keep them for 6 months, and that there's no real vehicle for a judge reviewing it. But my sense is that most hospitals do not keep the patients the full 6 months because managed care doesn't let them. And that they're constantly, after the first 3 or 4 days, if a person has private insurance, the insurance company is constantly pushing the doctor to make decisions about whether or not the patient ought to stay or not.
But is this an opportunity for judicial activism? Could the courts say, look, I said 6 months, convince me that the patient's ready for discharge before you discharge this patient? I know that doesn't happen, but technically there's a discrepancy here, because a psychiatrist basically has been told by the court that you have up until 6 months to work with this patient, and yet you're saying the managed care companies undercut that.
Well, except I'm the managed care company. I mean, the few cases I have had where families have come to me and said the managed care people are really pushing my son or daughter out, generally, if the hospital psychiatrist will really stand up to managed care and say, look, this person's committable, remains committable. If I discharge her, she will become suicidal and hurt herself. Generally speaking, the managed care companies will back down, but it's difficult, and it requires the hospital or the treating psychiatrist to become a real advocate in a way that they're not trained to do, nor should they be. I mean, it's not part of what their role is or what their job is. I think it's certainly true that many of the medications that are used today have allowed for shorter term hospitalizations. The more difficult question is, because there are a lot of patients who are not committable, but are not ready for discharge to their own apartment and the working world. They need to live in a supervised setting of some kind, either a very structured halfway house or even just an apartment where there's somebody who checks in on them, a case manager once a day or once every couple of days. And there's not a lot of that around there. around. There's not a lot of it available, and insurance doesn't pay for much of it.
Doesn't pay for it. So, though, is that a situation where outpatient commitment might be helpful? And I guess I'm interested in your position regarding outpatient commitment.
Well, as I understand outpatient commitment, as I understand most people talking about it, I generally don't like it at all. Because and I'm going to put a definition of what I understand it to mean before I describe what I don't like, is that outpatient commitment means that a patient can be ordered by a court to participate in a treatment plan, which usually includes medication, but may also include living in a halfway house or a sheltered environment or something more than just medication. And if the patient fails to do that, follow whatever parts of the treatment plan is, he can be taken and returned to the hospital and locked up again. That's what outpatient commitment means. And the major problem I have with that is that it seems to me that changes the standard for locking somebody up in a mental hospital. And mental hospitals, in my experience, are not very pleasant places. Patients suffer a significant loss of dignity and personal rights when they're locked up in mental hospitals. And the legal standard we have, and when the state's using its police power to lock somebody up, traditionally we do it because of a public protection interest. And it seems to me that there are patients, you've treated them, I've represented them, who leave a hospital, stop taking their treatment, and are not doing as well as they could, but are not dangerous, have not regressed to the point where they are committable in any sense of the word. They're making it okay, they're sort of living a lifestyle that their family may not approve of, and you or I may not approve of for our brother or sister or son or daughter, but they're getting by. And it seems to me if outpatient commitment means that a family member or a doctor or some other source is going to define the lifestyle they should have and the treatment they should be forced to take to acquire that, and the patient, either by total volition or even as a product of his mental illness, chooses not to do that, I'm not sure that's enough to force them to be locked up in a mental hospital again. And that's what outpatient commitment means to me. On the other hand, there are some categories of patients who I have represented, who you know from your Bridgewater experience, who would benefit from outpatient commitment. But it's a very narrow group of people. And those are people who were found not guilty by reason of mental illness, of some pretty violent crimes, whose treatment is well controlled by medication. And when they take the medication, there's most people believe they don't have a risk of recommitting the crime. And are ready to be discharged from a locked, secure hospital, ready to go into the community in some place. But you can tell because of their past violence that if they get unmedicated, if they stop taking their medication, it's likely they will do something again. And for that narrow group of people who are not guilty by reason of mental illness of a violent crime, I would support outpatient commitment, and I have in the past.
For the NGIs?
NGIs on certain crimes.
On certain crimes.
I mean, I don't think
violent
crimes, because those people, have shown clear evidence of their violence, of what they've done. Remember, a lot of people who are committed because of a likelihood of serious harm, you're still talking about a potential. They haven't committed serious violent crimes because they're civil commitments. But it seems to me that there is a certain police power that the state ought to have to keep people who have committed murders or other violent crimes, serious assaults, either locked up or under treatment. And it seems to me, and as I said, I have supported legislation to say that at a commitment hearing, a recommitment hearing of a person who was not guilty by reason of mental illness, the judge can say, if you take your medication, everybody agrees you're not dangerous. And I will permit you to leave the hospital, but on an outpatient commitment order, should there be such a thing, which says that as long as you continue to take your medication and check in with your doctor or the treatment team or whatever, you can continue to live in the community. But if you fail to make your appointments or fail to take your medication, I'm going to order that you be returned to court for a review to see what your status is.
Well, that would be okay with you.
That would be okay with me, as long as, once you had that review, the judge would then say, would still have to look at the existing commitment standard to decide whether to recommit him or not. Because we both know there are patients who get in arguments with their doctors not about whether they should take medication, but about the dosage or which medication they ought to be taking. And so if a patient says, well, I don't want to continue to take Prolixin, I want to try one of the newer medications, and the doctor's not willing to do it, it seems to me that shouldn't cause the person to be locked up just because of that.
See, Judge Sidney Hanlon was a guest on the show, and her objection to outpatient commitment was more that if the standard for commitment is met, then she'd feel very uncomfortable committing to outpatient versus inpatient.
I agree with her, and my sense is that outpatient commitment is not for that patient. It's for the patient who does not meet the standard for civil commitment, and who therefore, under our existing standard, is simply discharged and the court has no authority over them whatsoever. My understanding of the reason people want outpatient commitment is that they want to retain some judicial accountability or oversight over the patient who is no longer committable.
But who was once committed, probably.
Usually it would, or somebody who was once committed. And as I said, I have some problems with that except for the NGIs.
Although sort of a natural setting where some of it occurs is pretrial probation, where people are required to be in therapy. And
well, it's certainly, not only is pretrial probation, it certainly is true, and I have represented people who are charged with crimes, and like an assault or an attempted assault or assault and battery, where everybody in the picture understands that it was a product of their mental illness. That's why they did it, you know. And I have certainly seen cases like that where the judge is willing to say, you know what, I'll continue without a finding, I won't lock you in jail, but a condition of probation is that you take your medicine. Now that's a form of outpatient commitment. I don't have any objection to that because in a sort of legal sense, it's a voluntary choice the patient's having. He can say to the judge, I don't want that damn medicine, I don't care what you do, and the judge says, fine, we'll try you, if you're found guilty, we'll sentence you. It's your choice. And you know, all the rights of any criminal defendant are given to the patient, to the person while he's trying to be found guilty or not.
of course, now you're introducing yet another problem, and I think in the final segment, because we do have to wind down, we have a minute left before the break, you're talking about like competency to plea bargain too. And,
yep,
and
that is sometimes an issue.
Could possibly be a significant issue because someone might not fully really comprehend the nuances of what is really being offered and what the options are. Again, some ability. I think in the closing segment, which will follow the break, maybe we could talk a little bit about what families are supposed to do, how you might advise families who come to you for counsel when they have a situation, an outpatient situation that seems to be deteriorating. So why don't we come back to that after the break. Thank you, Robert.
As America has changed, Social Security has changed. A foundation of monthly income for retired workers was created in 1935. Then changes were made to provide for widows and widowers, and for disabled workers and their families. Later still, changes were made to ensure that benefit payments would always keep up with inflation. Now Social Security will need to change to provide for the retirement of 76 million baby boomers early in the next century. It's a big job, and it needs to be done right. so that Social Security will continue to help support not only the baby boomers, but their children and grandchildren as well. You can help draft the blueprints for the coming change by learning about the issues involved and our options. For more information, call 1-800-772-1213 and ask for the booklet, The Future of Social Security.
There are a few things you need to do to make your home safe for you and your family, like setting your water heater at 120 degrees Fahrenheit to prevent burns, and installing smoke alarms outside of bedrooms. If your home was built before 1978, have it tested for lead-based paint. Did I mention proper wiring?
For a free brochure on HUD's Healthy Homes and to learn how an FHA loan can help you buy a home, just call.
HUD and FHA are on your side.
I want to remember who I was.
I want to remember the old neighborhood.
My father's face.
Summer camp.
I want to remember
Everything.
The National Institute on Aging has a wealth of information dealing with serious memory problems. Call for details. 1-800-438-4380.
Everything.
Well, I think any number of areas that we've covered are clearly hot topics and of interest to the Alliance. I might first of all ask you, what is it going to cost me to come to you with my problem? And my problem is that my wife and I have a son in his 30s who has a history of psychotic regressions, who's been in and out of hospitals. He's at home doing fine, but now just stopped taking his medication a week ago, is already beginning to manifest some of the signs and symptoms of deterioration. He's been violent at various times in the past. We've been a little concerned for our safety. We need some help. We want to prevent deterioration. So we come to you. First of all, just a quick reference, if you don't mind. Just talk about norms in the field around fees that are involved, because I think people don't really have an idea. And then what kind of advice might you give?
Well, I can't tell you what the norms and the fees for fees are. I don't know what other people charge. What I do is I charge $125 for a consultation.
Okay.
I book an hour, but I take as long as it takes. Sometimes it takes an hour, sometimes it takes 2 hours. And a couple like that, like yourself, would come into the office, and we talk a lot about some of the things we've talked about today. I've written a lot about guardianship, and I can provide people with written materials, but we talk about what a guardianship is, what the standards are, what the legal process is for obtaining the guardianship, the pluses and minuses of the guardianship, and then other strategies that may work around forcing or encouraging the person to take medication or to regain his treatment without resorting to court, whether or not there's outside forces who are influential, whether the patient has a therapist who he believes in, or a former teacher, or a priest, or a rabbi, or a friend, or an ex-wife. I had one case where the person's ex-wife was clearly going to remain the ex-wife. She did not want to get back involved with him. But on the other hand, she was concerned about him, and she had some influence, partially because she had custody of their child. And, she wouldn't let him see the child unless he was well treated. So we can sort of talk about some of the other strategies one can attempt to encourage the person to get treatment.
Like what?
Sometimes I've suggested to people that by allowing the person to remain in their home without any duties or obligations, they're sort of enabling his mental illness. And that maybe it's time to think about having them try and fend for themselves, or try and get a job, or charge them some rent. I mean, or do those kinds of things. I try very hard to avoid giving sort of clinical advice. Mm-hmm. People come to me as a lawyer, and I try very hard to be a legal resource, but not a clinical resource. And I may give suggestions about other people they want to talk to. And frequently I'll give them the number of an Alliance chapter. Sometimes parents don't know about the Alliance. And so I'll suggest that they talk to Alliance members who have been through these kinds of things. Because certainly Alliance members have a lot more experience than personal experience, and they can give advice. But then I'll talk about what a guardianship is, and what the process is, and what the cost is. And generally speaking, if it's not a terribly contested guardianship that involves a major trial, our fee for doing a Rogers guardianship is about $1,500. It's more than that if we have to do a temporary and a permanent. But frequently, there are dangers in obtaining a temporary guardianship and then getting a permanent guardianship. A temporary guardianship is limited to 90 days by law. Frequently, it ends sooner than that. It takes about 30 days to obtain a permanent guardianship, just because of the court process. You have to get a citation and give official notice to all the heirs at law, and it takes longer. However, a permanent guardianship, once granted, is permanent. It's not carved in stone permanent. If the patient chooses to try and get out from under it, he can maybe do that. But from the court's perspective, once they grant the permanent guardianship, even a Rogers guardianship, there's only review once a year, and it's a pretty low level of review. A temporary guardianship, however, has a maximum life of 90 days, and at the end of it, it expires. And then if you want to renew it, you have to start all over again. It's like a recommitment. Mm-hmm. One of the problems with some patients, particularly in my experience, patients with bipolar disorders, is that you get a temporary guardianship and you're successful, you do a Rogers, and they're ordered to take the medication, and they take it. Then when you're ready for the permanent guardianship, they've been on the medicine for 90 days. And they look pretty good. Okay. And if they want to contest the permanent guardianship, they will be successful because the medicine works, there's nothing wrong with that. That's what everybody's trying to achieve. The problem is the temporary guardianship lapses, you don't obtain the permanent guardianship, and then a little bit later they deteriorate. You're not back where you started from because you've done all of that work for the permanent guardianship, the citation, and it's filed and it's in court. If they deteriorate again, you can then just go straight to the permanent guardianship. You don't need a temporary.
Well, why did you even bother with temporary? What are the conditions?
The only reason I would bother with a temporary guardianship is if the person has regressed so far that you can't wait for the permanent guardianship.
Which takes an average of
30 days.
30 days.
But the point I was going to make is that if you can wait and you know you have somebody who is, because of their history, fairly successful on the medication, I generally advise people, it saves cost because it's less court appearances for me.
To go for the permanent.
Yeah, to avoid the temporary, get the permanent guardianship, see if you can live with and keep hands on the person so you know they haven't disappeared, but sort of live with their craziness if they're continuing not to take the medication.
And the temporary takes how long to get?
Well, in an emergency, you can get it in 2 or 3 days, but generally it takes a week to 10 days.
So it takes a little while. It's a little quicker.
It's a lot quicker.
It's time limited.
But it's time limited, and as I said, particularly for the kinds of mentally ill people that we're talking about. Right. The real downside is that when the temporary achieves its goal, you prove yourself away from getting the permanent. When you're dealing with demented elderly people or mentally retarded people, it doesn't make a lot of difference because the treatment they get under the guardianship will not restore them to any competency. Their incompetency is more organic. Whereas with a schizophrenic person, the treatment will restore them to competency.
So if you go for an emergency, if you get an emergency guardianship, that'll last 90 days.
Yeah.
That's the temporary,
Yeah.
and it can be gotten on an emergency basis. What are some of the other remedies that families have? I mean, they can go to the clerk and get rid of apprehension.
If the patient is regressed to the point where the family thinks they're dangerous, either to themselves or others. And there's another thing that I think it's important I did a case a year ago with a young man who basically locked himself in his room in his house, in his family's house, and stopped eating. And he was phenomenally regressed, and the doctor diagnosed him as having the negative signs of schizophrenia. And even the independent doctor that I hired to represent him in the commitment hearing said that he wouldn't testify at the hearing on behalf of the patient because this young man was really exhibiting those signs. But I have seen families who have lived with that and not tried to commit him because they get him enough food to eat and he's in the house. You know, and so they keep, and he's not dangerous in any other sense. He doesn't strike out or anything else. But assuming that, and I think that may not be the right thing to do if he's really that regressed and you don't spoon feed him, you force him to sort of confront it. But anyhow, if the patient is dangerous, if you think there's a likelihood of serious harm, there's a couple of ways that you can compel him out of the house into a hospital. The first is if he has a treating psychologist or psychiatrist, you can ask them to write a pink paper. Okay. And they can write it. They don't have to, they're supposed to try to examine him. That pink paper should be enough to have the police come and take the patient to a hospital. If you can't do that because the patient doesn't have a treating doctor or you can't get a hold of the treating doctor or the doctor doesn't want to do it, anybody, doesn't have to be a family member, any individual can go to any district court and request a writ of apprehension. And to obtain that, you simply notify the clerk that you think there's a likelihood of serious harm. The clerk issues a writ of apprehension, which functions like an arrest warrant. Police go to the house, take the person, bring him to the court where he's examined at the court clinic, and then committed.
So the take-home message really is that families have a number of options, that they can be empowered basically to intervene. So in the last 30 seconds, any advice to family members on what they might do when they feel they're between a rock and a hard place?
No, I don't have any. I mean, I think you might want to talk to an attorney. I think that the hardest thing is to be in that place where the person's not committable and you can't force them to and they can't lock them up in a hospital and you have to live with it. And I don't have any real good advice for that other than to, maybe talk to a mental health professional yourself about how you can come up with strategies. Because I think that the strategies are more clinical than legal. I think these things lend themselves to clinical issues rather than legal ones.
Well, on that note, thank you very much on behalf of the Norfolk Alliance and Mind Over Matter. I very much appreciate your being here, Robert. Thank you.
My pleasure.